taken out your valuable time and having taken the effort to make it here. I have no words to thank the honorable dignitaries on the dais for their words of endorsement for not just the book but also for me. No amount of words are enough. I will leave it at that. It's a very exhilarating thing to hear. That's all I can say. So I thank Dr. Justice Shalini Phansalkar Joshi, Judge Shri Sunil Vedpata, Mr. Amit Haryani, Mr. Nikhil Satrapande, and Mr. Ganesh Shanmugam. I thank each and every one of you for the kind words. That said, I welcome you all to the launch of the handbook on domestic arbitration in India. So, my family, my friends, my colleagues, senior members, some of whom from the Pune Bar are present today, Mr. Kanetkar, Mr. Bhalerao, Mr. Ganu, Lalita ma'am, Ashish sir, all of you all. My clients and my parents, Dr. Anjum Datta and Mr. Vijay Datta. While I could begin by speaking about the handbook itself, given the words that have been said by such distinguished names within the legal profession and in the arbitration space, it would be a disservice on my part to say anything about the book, or at least say too much about the book. What I will do instead is give some insight into why this book came into being, and more important, how the book came into being. So I'll start at the beginning. My first brush with the subject of arbitration was while I was part of this great institution as a student. It was a subject I believe was taught to us in the 4th year, back in the year 2015. Now, of course, my interests back in the day were to merely pass the university exams, and so my knowledge of the subject was quite subsurface, to say the least. That said, for some unexplainable reason, the words SBP, Patel Engineering, judicial in nature, Booz Allen Hamilton, arbitrability, and so on, they never really left my mind. Now, I remember these words, I never forgot them, but I had no inkling of how many thousand pages deep these seemingly inconsequential, at least that's how they appeared to me back then, or small words ran. My understanding was subsurface, I say, because to my uninformed mind, I must confess, there seemed to be no significant difference between arbitration, conciliation, and mediation. They all seem to be different shades of the same color. Color which sure looks beautiful, but seemed like it would be used on the canvas of everyday private party disputes. Fortunately for me, and I must say unfortunately for the arbitration ecosystem of the country, my subsequent interactions with students, people from outside of the profession, and even within the profession, made me realize that I wasn't alone in this understanding. It was only when I finally read the landmark ruling of the Supreme Court in A. Ayyaswamy versus A. Paramaswaram that I really applied my mind to the subject of arbitration. It was a judgment on the issue of arbitrability in cases where pleas of fraud have been raised. And I read that judgment for the purposes of authoring an article while I was at Haryani & Co. But it was only at this time that I first put any thought to the subject as a whole. And quite frankly, I didn't get my first crack at detailed or thorough arbitration work until 2 years after. That's the first time that I really applied my mind to the Act of 1996 itself. Now, the arbitration went on for years. Over 4 years to be precise. But when it did end, it didn't take more than a year for the parties to finally put an end to their dispute. And that is when I finally realized the power of this system or method of resolving disputes. Why do I say that? Because I assure you that a case of that kind would remain pending on the file of a court of law for decades and decades. That is the unfortunate truth of our justice delivery system. And I must say this, once a practitioner spends enough time in the legal system, so to speak, we realize that our issues are not to do with judicial discretion or court holidays or any one of the 100 different reasons that are given. They have to do with reasons which run much deeper. And our issues, in the manner of speaking, are systemic. That also includes us as a society or as parties. Irrespective. Coming back to the subject of arbitration itself, it was only at this point that I truly understood what a well-conducted arbitration could actually lead to and do. Now, given that a lot of each of the dignitaries have shed light upon arbitration as a subject, I won't take up too much time, but let me define arbitration in the best way that I have found it, such as to explain it to a newcomer. One might say that arbitration is an expedited way of trying a case before a judge or a decision maker who is known as the arbitrator. Now, the arbitrator is required to decide this case in accordance with the first principles, so to speak, of civil procedure, for that matter even evidence, minus the extreme technicalities which usually delay a civil trial. Now, this judge or decision maker will also keep periodically nudging the parties to explore possible settlement of the dispute. What that does is that this close-knit, quite literally, purposeful, and almost and very specific nature of the proceedings is what creates the ideal conditions, I believe, for an early settlement of disputes. And in any event, even if a dispute isn't settled, it even after contest still leads to an early disposal or an expedited decision. What's important is that it is arguably one of the fewest forms of adversarial dispute resolution that financially incentivizes the early settlement of disputes by an arbitrator. My case in point being Section 29A2 of the Arbitration and Conciliation Act of 1996.
This need will be fulfilled by this book. He has covered the arbitration from the various aspects, like what can be the arbitration agreement, whether the clause of arbitration in one contract can be read in another contract executed between the parties at the same time, whether non-signatories can be bound by the arbitration clause, whether who can be appointed as an arbitrator. Because till now our concept of any adjudication involved necessarily that such person should be having the knowledge of law or having the degree in the law, but arbitration law is not like that. We are having domain experts in the arbitration, and that is such an advantage for adjudication because they are having the expertise in the field. He may be a CA, he may be an engineer, he may be a retired superintending engineer. So many persons, and I had I'm a pleasure to work with them and to know their perspective to be incorporated in the award to be passed. And this is one area where arbitration, one can say, excel to the traditional litigation. Here we can work in panel, we can work solely, single-handedly. So apart from these, we find that these are not easy things because the law is such that it has also undergone several changes. Arbitration law of 1940 has undergone the change in 1996, 2015 and again in 2021. To cover all these changes made in the statutory law, the judge made a law.
Aman, that was Aman Datta, of course. Yeah. So Aman worked at our Pune office for some years, and then he came to the Bombay office where I really worked. And he worked on
on several litigation matters and some of them with me, right? And he did them effectively and he did them well. And applying the same principles that I had heard of earlier, but he actually applied them. And again I thought, this guy is going to go places. Yeah.